Welcome to The Explainer. Today we are digging into a really wild story about a homeowners association, a resignation that was, well, let's just say it was very clever. Some people called it a brilliant use of the rules, while others saw it as a blatant power grab. It all comes down to one fascinating little loophole.
So let me ask you this. Can a board member just quit their seat only to be immediately appointed to a different, longer-term seat on the exact same board? Now, this isn't just some weird hypothetical. This exact thing happened at a condo association out in Arizona, and it got so heated it ended up in a formal legal hearing.
Okay, so check out how fast this all went down. On September 30th, a board member resigns, right? Homeowners are told, don't worry, you'll get to vote on the replacement. But then just 3 weeks later, the plan completely changes. A longtime board member, Joan Robley, stands up at a meeting and resigns her seat. And literally minutes later, the rest of the board appoints her to fill the other vacant seat, the one with more time on it. No vote, no warning. You can imagine it caught a lot of people by surprise.
And here's why it was such a big deal. This wasn't just some simple shuffle. See, Joan Robley only had 3 months left on her term. She was about to face an election. But with this one move, she effectively traded her 3-month term for a brand new 27-month term. That's over 2 years. And the best part for her? She got to completely bypass that upcoming election.
As you can guess, this move did not sit right with everybody. One homeowner, a guy named Yelenik, decided to challenge it. He filed a formal petition, and he argued that what the board did was completely illegitimate. He said, "You can't call this filling a vacancy. This was a board term swap."
Yelenik's entire case really rested on this idea. He said, look, the whole point of filling a vacancy is to fix a problem, right? The problem being that the board is short-staffed. But this move didn't fix anything. The board started with 4 members, and after this whole song and dance, it still had 4 members. He basically argued it wasn't about helping the community, it was a transaction designed to help one person.
The petitioner basically called it a shell game. He argued that according to the HOA's own bylaws, the board is supposed to have 5 members. Well, this little shuffle didn't accomplish that at all. They went from 4 members down to 3 for a few minutes, then right back to 4. The main problem, the vacancy was never actually filled. So he contended this violated their own rules and maybe even Arizona state law, which he said stops a board from just, deciding how long its own members get to serve.
Okay, so now let's flip the script and look at the HOA's defense, because from their perspective, this wasn't some shady backroom deal. They argued that what they did was not only perfectly legal, but it was actually necessary for the good of the community.
Their whole argument really came down to one thing: experience. They pointed out that Miss Robley had been on the board for 15 years. 15! Meanwhile, 3 of the other members were pretty much brand new. So the board's thinking was, hey, we just lost 1 member. We can't afford to lose all this institutional knowledge, too. They felt they needed her leadership to keep things stable.
And on the legal side of things, they felt they were on totally solid ground. Their argument was pretty simple, actually. They said, the rules give us the power to fill a vacancy, but they never say who we can or can't appoint. There was nothing written down anywhere that said you couldn't appoint a former board member. So, in their eyes, the second Miss Robley resigned, she just became a regular homeowner again, which made her a perfectly eligible candidate for the other open spot.
So you've got 2 completely different ways of looking at the exact same set of rules. The homeowners saw a violation of the spirit of the law, a move that just felt wrong. The board, on the other hand, saw a practical solution that followed the letter of the law. So, who was right? Well, that's what the judge had to decide.
All right, the moment of truth. After hearing from both sides, the judge went through the bylaws, the state laws, the whole sequence of events, and then came back with a final decision.
And the ruling was crystal clear. The judge sided completely with the HOA. The homeowner's petition was denied. Yep, despite all the arguments about fairness and transparency, the board's move was found to be 100% legal.
So how in the world did the judge get there? Well, it all boiled down to a really powerful legal idea. If the rules don't specifically say you can't do something, then you probably can. What's so wild is that the judge actually called the board's choice questionable in the official ruling. It's like they were admitting, yeah, this looks pretty bad. But how something looks doesn't matter in court. An action has to break a specific written rule. And this move, well, it just didn't.
This one sentence from the judge's decision really says it all. It perfectly highlights that huge difference between something that feels wrong or is unpopular and something that's actually illegal. The board could have done a million other things, sure. They made a controversial choice, but it wasn't an unlawful one.
So, in the end, the board won the case. But this whole story leaves us with a massive question, and it applies to any group with a rulebook. Are your rules actually written to do what you think they do, or are they full of these little loopholes, just waiting for someone clever enough to find them? This story proves that if something isn't explicitly forbidden, it's very often allowed. And that, right there, should make anyone in an HOA take a much closer look at their own governing documents and ask, what other questionable moves are hiding in there, just waiting to happen?